First though, we welcome back Catherine Sherwood, Director from The Engine, and Martelli McKegg partner Tim Orr, Trusts and Asset Planning Specialist, to look at how the upcoming changes to trust law could affect so many Kiwis and small business owners. Good morning, both of you. Nice to have you in my lounge, Tim.
Thank you, Carly.
Good morning, Catherine, as well.
Hi, Carly.
Tim, we have heard a lot in the newspapers and various publications in the last few months about these new trust changes that are coming into effect. Who is affected by this?
Well, I think that's a really good question. I think the fact that New Zealanders have made significant use of trust to the extent that the government now estimates that there's between 300,000 and 500,000 trusts in New Zealand, that gives you a really good impression that this is going to affect a lot of Kiwis. Trusts typically have between at least 2 or 3 beneficiaries, but some of them have a lot more. So it is going to be something that will have an effect on a large segment of the population. Now, the Act that we have here comes about as a large piece of work carried out by the Law Commission over about 10 years. And the aim was to clarify the law around trusts and the way in which the administration of them is being carried out. But most importantly, it also hones in on an important aspect, which is how beneficiaries can hold trustees to account.
Right.
So the one thing I think it'll just clarify is what a trust is, just for a couple of seconds. So a trust is effectively a mechanism by which the property can be held by trustees, who you should really think of as caretakers, for the benefit of the beneficiaries. Now, the beneficiaries are usually people who are named in the trust deed, and they're the people who were named by the settlor, who usually had what we call natural love and affection for them. And whenever we think about what the settlor's intentions were in establishing a trust, we think about these are people that they wanted to benefit, and in some cases, especially more recently, they've put together what are also called memorandums of guidance or memorandums of wishes, which say how they expect the trustees to act, particularly if the settlor has died or if the settlor isn't involved as a trustee of the trust.
Tim, I have to say, I've had a trust. We've had a family trust, the Flynn Family Trust, for 15 plus years. I have never understood it as succinctly and wonderfully as that. Thank you so much for that explanation. Catherine, how does trust law relate back to business?
Well, for starters, many business owners, they've got their personal assets in a trust for protection and also for legacy. The question on everybody's mind now is what good is it to have a family trust to a business owner who's suffering financial hardship right now? For me, it'll depend mostly on how well the family trust was set up in the first place and the management of it since its inception.
Tim, you mentioned beneficiaries holding trustees to account. If trustees hold the property, don't they have the rights of property owners?
Okay, so that's a really excellent question, because traditionally in New Zealand, the trustees often include the settlor, who was the person who originally established the trust, alongside a number of other trustees, one of whom is often what we call an independent trustee. Now, sometimes that's a lawyer and accountant, but that's not always the case. But it is often the case in New Zealand that the settlor is one of the people who remains on the name of the title to the property or other asset. So because their name's always there, and because the trustees have the right to buy, sell, or even distribute the trust property, in a lot of people's minds, there often has been little or no change. However, the key bit about trusts are that the trustees have to think about the needs of all the beneficiaries before they make any decision in relation to the trust property, and they must always do so to benefit somebody who is actually named as a beneficiary of the trust.
Right, okay, wonderful explanation. Catherine, we appreciate that you're not a lawyer, so how do you guide businesses here?
Well, firstly, I do leave the specialist work to specialists, but as a business advisor, we've got to be abreast of changes that are coming up in law. So the question of business owners is to whether they've sought advice on upcoming law changes, especially if we know that they have a trust. Having worked years ago for trustees executives and having family trusts of my own, I know when things can go severely wrong.
So Tim, what is changing under the new law?
The biggest change is the fact that trustees now have to carefully consider whether or not there is any genuinely good reason why all the beneficiaries of the trust are not told that the trust exists, who the trustees are, and the right that they have, and the fact that they have the right to request further information. Now, this request for further information is going to be a really interesting one for many Kiwis, because now the beneficiaries have the right to request information relating to what is held in the trust, what actions have been taken with regards to those assets, who distributions have been made to and if they have been carried out, and any other questions regarding how the trust is being administered. Now, the rationale behind that is that the intention is that the beneficiaries should be able to ensure that the trustees, who we refer to as caretakers sometimes, have actually been acting in accordance with the terms of the trust deed and can be held to account.
Okay, wonderful. What are your thoughts, Catherine?
Well, as I said previously, a trust is generally set up to be a legacy for beneficiaries and all care must be carried out. In my experience, most issues arise from failure to communicate or, most importantly, failure to involve those people that actually benefit.
So Tim, what you're saying now is that the trustees of a typical mum and dad trust, which many Kiwis have, now have to tell the beneficiaries what's in the trust.
Yes, and that's going to be a big change, because in most trust deeds created from the early or mid 2000s onwards, the beneficiaries of the trust, of a typical mum and dad trust, let's say, will typically be mum and dad themselves, their children, and hopefully their grandchildren.
This is us.
Yeah, and everyone's hoping they're going to have grandchildren, and that's fairly straightforward. However, older trust deeds in particular, and those that are before 2000 are a really good example, have a wide range of beneficiaries, and those beneficiaries often include anyone related by blood or marriage, and often can include any spouse or de facto partner of any of the beneficiaries, and can even go further and include any charity that's ever been in existence, and have a wide range of beneficiaries. And these are all beneficiaries that the trustees owe those duties that we talked about earlier to. So I would really encourage all Kiwis who are acting as trustees of any trust to carefully read the trust deed and ensure they know who the beneficiaries are, and check to see if they're comfortable with who those beneficiaries are and if that actually reflects what was intended when it was established.
Because that can change over the course of years as well as relationships change. Thank you, Tim, for that. And Catherine, what is the main message here from you?
Well, coming back to what you said, Carly, you've got a family trust. So anyone who has a family trust, who does also have a business, or even if you've got a family trust, the law is changing, and it's a good reason to check in with your current lawyer and get a review or get a second opinion. We brought Martelli McKegg on the TV today because they're a provider to the Engine. We know that they'd be happy to assist on a second opinion for anybody. And we at the Engine would gladly speak with any business owner to ensure that they've considered protection of their personal assets and mitigated any personal risk exposure to their assets and to their legacy.
Thank you, Catherine. Nice to see you again.
Thank you.
And thanks, Tim, for coming into our lounge today. Nice to get your advice as well.
Thank you very much, Carl.
And for more great business advice from Catherine and her team, or Tim and the lawyers are at Martelli McKegg, you can head to theengine.biz.